Yes.
Adjournment request.
Well, item number 9, my lord, there is a state preferred appeal, my lord. Here, my lord, another department is the health department has also preferred one appeal. I pray, my lord, it may be taken up together in some other day. It relates to medical admission. The respondent number 1, who has the writ petitioner, he has been allowed admission and he is pursuing. The appeal is against the 1 lakh cost that has been imposed upon the state.
That's all right. We'll deal with it today.
That's, my lord, let it be that other appeal filed by.
Where have you challenged the other? What is the other appeal for?
My lord, here, my lord, the first appeal which is listed today has been filed by the sociology.
The other appeal is where? Why do you want an adjournment? We want to ask you.
My lord, let the both appeals come together because the health department has preferred an appeal.
Not listed.
Not listed today, my lord.
Which is that appeal?
Yes, but it has been registered,
That is against what?
same order, my lord.
And who has filed it?
That has been filed by the health department. My lord. Our claim is that, my lord, because of delay in receiving the
State of
report.
Assam and Health Department are not two entities as such.
I understand, but my lord, in case of the liability part, my lord, 1 lakh to the state, who will move, my lord, that will have to be ascertained by a lot.
Look, we will say whoever has to pay, because you see, this is a restitutive, decision.
No, my lord, here what
It's not a public law remedy.
Yes,
It's not tortious
my lord,
thing. It's
my
not damages. Even if you're not at fault, bona fide.
my lord.
But there has been some breach of some entitlement. He couldn't get into the admission, and therefore, what would be the quantum? That is the only thing that you can ask. See, Rudal Sa, which has started from my state,
My lord,
and there are many other cases.
yes, my lord.
Article 32 and Article 226, they entitle without, assessing. It's not a question of how guilty you were
My lord,
as the government, as the department.
my lord.
Now, this would not be read against you as such. But then that person must be compensated who has lost 1 year.
My lord, in
That is
fact-
the law.
But my lord,
If you're aware of the law with respect to compensation, I don't think you have a case.
No, my
Now,
lord,
we will say that you are bona fide. The moment you found that he does not belong to that tribe, to that
it is not
category,
admitted.
but then there was some delay and ultimately it was found to be, your
Yes, it came in his
objection was
favor.
found to be
Yes,
wrong. It
yes.
came in his favor. So
And it has
if
happened.
he had not got admission, if he had got admission in the same session,
Yeah.
all right. But 1 lakh, I think
Too late.
there is a case by the name of Kumari versus
Yes,
state of
yes.
Tamil Nadu.
As Krishna said, actually.
That is different. Kumari versus Tamil Nadu. This is the same thing happened, and 1 lakh compensation was given. Nobody interfered.
My lord.
Well, what do you want? You have to pay to the student.
Then, my lord, I leave it to otherwise, my lord, if both can be, my lord, disposed of in a day, my lord, let it be in coming Friday, my lord. I'm not praying for it. Because, my lord, he is pursuing the course, my lord.
All right. All right.
Bless me.
Like here, as prayed for. But then the 2024, you appear for the student.
Yes, your lordship.
2024-25 session, he's there.
Yes, your lordship.
In fact, by filing affidavit, we admitted that, my lord, we will give him admission, provided the order is.
That is not a confession given.
No, because, my lord,
he or she
medical
is the
admission.
student, she or he?
He, your
He, my lord.
He has gained it. He has earned it.
Lordship.
He passed the examination. He got the marks.
Lordship.
He contested.
No, 30th September is the last
I
date
mean,
for admission, my lord. It
you
came-
run the risk of the amount of compensation to be enhanced. Mr. Kath, you run the risk.
in
Take
that-
your call.
That's why only in that case, we will also have the instruction from a client whether I'd like to pursue or not. If that be the issue, then, my lord, you will be
All right.
let it be on Friday, my lord.
As prayed for on behalf of the appellant / state of Assam,
Hmm.
re-notify on, give a date on 11th of November. Take a
Along with
call.
this appeal, my lord, I'm.
Don't pursue it, it's better.
Yes.
It is not castigating you in any manner. If you want, we can even clarify
Yes.
that this will not be read against the department. There was some flaw somewhere,
Lordship.
and the entitlement was
Yes.
of the
Otherwise,
person
he
was
was deprived of 1 year, my lord. It appears. Then, my lord, that clarification will do, my lord. Let it be, my
in
lord.
educational institute. We will say that.
Yes.
We will say that. No
Because
difference.
it will be a precedent otherwise, my lord, tomorrow. That's why.
Tomorrow, if you do that, it should act as a
No, my
precedent.
lord, we are, it will
If
be
you
done within
understand-
time.
No,
It will be
don't
done
fear
within
that.
time.
Don't fear this to become a precedent. We want it to become a precedent. that please don't raise objections in a frivolous manner.
Lordship.
You're playing with the life of a student.
No, my lord, that examination was made pursuant to the court's order, my lord.
I know. We have, see,
Hello.
you have to be very, you have to be very careful.
No.
It's a very, delicate task.
My lord,
Now, the students are they have a very fragile temperament.
my lord.
If they get something and you snatch it without any reason, I mean, they can't be made to understand.
My lord.
And you must care for their fragility of the emotions.
My lord.
Don't you see these students have picked up the habit of saying, I quit. When they fail, when they don't get good marks, I quit. What is this? I
Lordship.
mean, they have to become strong, but then you have to be careful.
My lord. Lord.
So talk to your client. The compensation, if you pursue, it might be enhanced. This is no threat because we have our own idea.
Lordship.
We don't say that you acted in a malified manner. No,
My lord.
something happened and the person lost a year.
The last date of admission was.
That is the only effective remedy now.
My lord.
And don't ask the student to forgive you.
No, that was not his prayer also in the repetition.
In fact, the state would do better by paying 1 lakh rupees. I know of a judge of a high court,
My lord.
though he was transferred from his parent high court. But when all this objection was being made, he immediately wrote a check of rupees 1.5 lakhs in favor of the student.
My lord.
He was so stirred up. Take care.
Lordship.
11th.
11.
Along
Oblige, Your Lordship.
Yes.
along with that appeal.
That filing number is published.
Ezeligo, what is your name? Mr. Counsel, what is your name?
B. Gogoi.
Huh?
B. Gogoi, madam.
Mr. B. Gogoi, learned advocate for the appellant, submits that another appeal by the Health Department
Madam.
has been filed, and that this case be listed along with that appeal, so that both the appeals are decided together. Let this matter come up along with appeal number so on 11.
Madam.
Oblige.
May please, Your Lordship. Lordship, regard to item number 4, Your Lordship, the similar matter is also listed on Monday, Your Lordship. A different court.
Why have you come here for on Saturday? If you take adjournment in all cases,
Lordship,
there are
may
adjournment
also
slips.
issue
We
notice
can't
also.
help it.
Lordship may issue notice also in this case, then I'll wait, Your Lordship, for my turn.
Item number 4, let's see, pay disparity.
Yes, Lord.
And which item, which it is,
It is before Honorable Court number 3 in item number 9, I think, Lordship. Repetition 6187.
Another matter,
this will be heard on that. Okay. What is that number?
WBC 6187 of 2025, already listed, Lordship.
6187.
Yes, Lord.
Like here, the Land Council for the petitioner submits that similar matter in WPC number 6187 is slated to be listed before DB3 on
Monday, Your Lordship. 3rd of November.
on 3rd of November. Let this case also be listed along with the same case before the same bench.
Much obliged.
May it please, Your Lordship. May it please, Your Lordship. Lord, I beg to mention item number 6, 7, and 8, my lord. with the consent.
Adjournment slip has been circulated. All right, with the consent of the other side. Give a date. It all goes in January.
27 January.
Grateful, my lord.
may I please, Your Lordship, I beg to mention item number 10. We have submitted adjournment.
Adjournment slip circulated with the consent of the other side. Now, the only thing left is. Yeah.
That's 1, 2, 3.
No, railway cat. Yes, follow.
31 January. Daily list for this item 1.
May it please, Your Lordship.
My lord, the petitioner association has been defunct. My lord, thus the petitioner is not facing this writ petition and seek to withdraw this present petition.
What is your name?
D. Rathi, my lord.
Hmm?
D. Rathi.
Lee Rakhi.
My lord, I am appearing on behalf of my senior Mr. A. Goel.
Mr. G. Rakhi, on instructions from Mr. A. Goel, learned advocate on record, seeks permission to withdraw this writ petition. Dismissed as withdrawn.
Much obliged to you.
Item number 2.
First time.
Lordship, not first time. Service not completed. They have now it is complete. They have also filed objection to
Yes.
20.
Perhaps then file our objection against the IA.
All right. Let's get. Delay of how many days?
224 days.
And what is the matter?
It's a
Indisciplined constitution.
disciplinary proceeding, and thereafter the services of the writ petitioner was dismissed on the ground of unsuitability.
If you repeat notice not on record.
What is not on record? Again? For the, we have heard the land counsel for the parties. This is an application seeking condemnation of delay of 224 days in preparing the appeal. For the reasons stated in the
Paragraph 7, Lordship.
application, we are inclined to condone the delay. We order accordingly. The delay is condoned. The application stands allowed. The appeal be processed and be listed January.
The appeal that objection that has been filed that may be deflected.
7 January.
Obliged.
Item number 3.
This is the admitted.
Sorry, my lord. They may be directed to serve a copy of the appeal because it was not.
Have a copy. January, don't worry, Mr. Counsel. Appeals, there is a limited aperture.
That's it, Lord.
Don't you worry.
Lordship, this is for confirmation of date sentence.
That's right. Any appeal filed?
No, we try to verify. Filing number, Lordship, they have got only the filing number. Hasn't been numbered.
Let this be listed along.
I'll avoid that
Yes.
with filing number.
Let this reference is not actually admitted. Appeals are admitted, reference are just decided.
Lordship.
Let this reference, where are the appeals?
No.
An amicus has to be appointed, Your Lordship.
Now it depends, who is the lawyer in the appeal?
They'll
Now
like,
for appointment of amicus, we would not appoint the same person as amicus, yeah?
no, they probably his name is not named in the panel of
Who
Honorable
is-
Guwahati High Court.
Who is?
Some core. Core.
किसको करना? तीजे महंता कर
His name is not there, Your Lordship. Only senior advocates name appear in the panel list.
एक बार तो उसको सुन लिया। कौन? कैसा? लिखिए। Come up. This death reference number 1 of 2025 be listed along with criminal appeal number so and so. In order to assist this court, we appoint Sri Z. Kamath, learned senior advocate, as the amicus. List this reference along with the appeal on. Those appeals have been admitted.
No, it hasn't, only filing number
Not-
hasn't been registered yet, Your Lordship.
The records have to be called for. No?
Each appeal will put- not this way, but it is filing. We will get quick.
Anyway, so we will fix a date for reference. If the appeals are listed, just remind us. No, we'll take care. this death reference 1 of 2025 is admitted for hearing. We appoint Sri Z. Kamar, senior advocate, as amicus to assist this court. Stop. This shall be listed along with the criminal appeal whenever it is filed, preferably on, we have a date in December, on 8th of December.
Lordship. Deeply obliged.
Item number 5.
Now we are not happy with the order.
Lordship,
We are not happy with the, I mean, we are observing in your favor, Mr. Chakravarti.
Lordship.
So notices have to go. Let notice be issued. How can you say, how can you stop and then not pass an order? For vacating the stay, we need to hear the other side. There's some,
Our intention is to keep the 11 seats vacant. The rest of the lay allows us to fill. That was the prayer before the
no, we will remove that. And we will decide it finally.
Lordship.
That's no way to forestall, appointment of branch, station managers, station masters.
Station master, Lordship.
Done. Yeah. Tribunal doesn't understand. Doesn't care.
नहीं, that if 11 was vacant, that was the only prayer. Extend allowing them to initiate press notification for remaining vacant posts by keeping 11 posts. That is, that will not work.
Why does he want that? Because 15, all 20 were appointed. Now this will unnecessarily stop
Now, keeping
further
the 20
litigation.
apart,
20 persons were sent for training.
Lordship.
Out of them, only 11 challenged it.
Lordship.
11 challenged the cancellation.
Lordship.
The others will follow suit.
Lordship.
Therefore, if you ask for partial vacation of the stay order with respect to 11,
Lordship.
I mean, keeping 11 reserved and then 9, I think you would end up in further litigation. So we will finish it off.
Lordship. Lordship.
You will
Now, even we're ready to keep 20 apart, Lordship.
Some more days.
get with
Sardasti.
Lordship.
Here. The petitioner / Union of India is aggrieved by 2 orders passed by the tribunal. One dated 19/12/2022, passed in OA number 263 of 2022, whereby any further action regarding the selection process for 20 station masters posts under 25% departmental promotion quota has been stayed, and order dated 5/6/2024 in miscellaneous application number 48 of 2024 arising out of the same OA, whereby the plea of the railways has been rejected. The plea of the railways for vacating or modifying or assigning the interim stay order has been refused. The respondents herein are 11 of the 20 selected candidates for the post of station masters. Next, a notification was issued on 25th of June 2021 by the DRM Lunding for the purposes of filling up 20 station master vacancies, bracket group C posts in level 6 under 25% departmental promotion quota from group D staff in the traffic, bracket operating, bracket closed branch. The candidates had to appear in an examination, whereafter they were to undergo 90 days training. The respondents and 9 others were selected and they were sent for 90 days promotional training at Alipurdwar Junction, where they completed around 73 days of training. While all this was happening, a complaint came from a candidate who was not selected, alleging that 12 answers in the examination paper, in his examination paper, were wrongly marked as incorrect. The objections were the objections raised by the candidate referred to above were examined by the railways, but only 4 out of those 12 questions were found to be incorrectly marked. An exercise was made by the railways to see whether the candidate would clear the test in his category if he were to be given marks for the 4 questions which were wrongly marked. But it was found that he could have only qualified for an unreserved post, which had already been filled up. And if that exercise were to be executed, one successful candidate will have to be displaced. The railways, in its wisdom, citing this irregularity in the conduct of examination and the resultant breach of the reservation balance, cancelled the entire process. The selected candidates, including the respondents, were informed on November 8, 2022, and they were recalled from the training. They were asked to return to their substantive posts with a clear assurance of fresh selection without prejudice to their rights. The respondents preferred OA number 263 of 2022 before the tribunal, seeking annulment of the cancellation order, a direction for continuation of the training, where only 17 days of training was left, and a bar on fresh selection for the 11 posts on which they were appointed. Before the tribunal, the railways defended the decision of cancellation of the process on the ground that it would have been only in the interest of upholding the merits intricacy and fairness in the examination process. That apart, it was argued that mere selection or being sent for training would not give any vested right to the respondents, especially when a fresh selection process was to be initiated without any delay. The tribunal, by order dated December 19, 2022, stayed any further action with respect to the selection process where the respondents, along with 9 others, were selected. And when an attempt was made to have the stay order vacated, attempt was made by the railways to have the stay order vacated by filing MA number so-and-so, MA number 48 of 2024, and the same was dismissed. Mr. Chakravarti, learned advocate learned Central Government Standing Council submits that the reasoning given by the tribunal for not interfering or recalling or modifying the earlier stay order dated 19th of December 2022 was absolutely not tenable, for the reason that the tribunal did not appreciate that with the stay over any further fresh initiation of recruitment to the post of station masters, the railways were finding it very difficult to man railway stations and ensure punctuality of the running of trains. A queer logic was adopted by the tribunal in rejecting the MA number
48 of
48 of
2024.
2024. The matter is still pending before the CAT.
Lordship.
Can you direct the CAT inside? We can send you back to the tribunal with a request to decide it immediately
Expeditiously. Within the
within a
time,
period of 30 days.
Lordship.
But for that also, we have to hear the other side. Notice has to be issued. Otherwise, all orders without notice, nothing can happen. We can do that. Let notice be issued to the respondents on steps being taken by the appellant within a period of 2 days, including service of dusty notice. Returnable. Give date after 15 days. After the expiry of 2 weeks. 1 week. For filing requisites, 1 week.
Yeah.
After that, 15 days. Notable on Swansea. We are absolutely not in agreement with the order of the tribunal. Absolutely not. You could have finished it today. All right. Then no other matter.